Thank you, Mr. Speaker. I rise for the second time in this House to speak to Bill C-11, an act to amend the Copyright Act. The first time I had the occasion to speak on the bill was, of course, a second reading on November 11th of last year. And I had hoped at that time, looking at the bill, that we would see significant improvements made through the committee process. This is a bill that, as all members know, has had several tries. The first attempt to bring copyright law into the digital age was made by the previous Liberal government back in 2005. And then, of course, subsequent bills were brought forward, most recently C-32, which is pretty much unchanged as what we see now as Bill C-11. And in that process, between 2005 and the previous Liberal government's attempt, and the bills we have through this current Conservative majority, what we've seen is leaning towards the rights of primarily U.S.-based entertainment industries. Now, I'm not a member of the parliamentary committees, and that is something that I certainly am not making the point, Mr. Speaker, to complain. I understand my position here as leader of the Green Party of Canada. The Green Party is a recognized party in this House, but my rights and obligations and opportunities are closely aligned with what would have happened if I'd been a member of no party at all and been an independent. Strangely enough, that does give me now, at this stage, at report stage, superior abilities to bring forward amendments that are substantive, that I could not bring forward today had I been a member of the committee. But with that small digression, I just mentioned that although I'm not a member of the committee, I tracked very closely what occurred at committee, and thanks to the able assistance of wonderful young people who work on my team, I'm very grateful for their help. I was able to carefully monitor the evidence and review the expert witnesses and their testimony that came before the committee. It was very compelling testimony that was heard from very knowledgeable experts in the field of copyright law in the digital age. It is admittedly a complex field. One of those experts who is often cited and who has made valiant efforts to see this legislation improved is, I think, one of the country's leading experts, professor at the University of Ottawa, Michael Geist. He's been saying for some time, and I invoked his words when I first spoke to this bill at second reading, that the bill was, quote, flawed but fixable, unquote. Well, we had a chance to fix it in committee and we didn't. It's my hope that the Honourable Minister of Heritage, whom I think deserves a lot of credit for the bulk of what he's done on this legislation, will allow his caucus and government Conservative members to consider favourably amendments being put forward now so that this bill, when passed, will be not just new copyright legislation, but excellent copyright legislation. We have that possibility, but we will need amendments to get there. The 19 amendments that I'm putting forward today fall in two general areas, and Mr. Speaker, you've grouped them as such, and I recognize that, but I propose to speak to both groups at once. The two areas are, one, to improve the clarity around the term fair dealing, particularly in relation to the new insertion of educational provisions, and secondly, to redress the overly onerous provisions to protect material against digital locks referred to in the law as technological protection measures, or TPMs. And I propose to try to explain these in layman's language in the next few minutes to make sure that they have a fair chance of being accepted by other members of this House who, like me, weren't on the committee, but perhaps, unlike me, weren't following the evidence as closely. Fair dealing is a very straightforward term, but it doesn't actually have the meaning that fair dealing sounds like you're making a deal with somebody. This is basically copyright law, so what we're saying is it fair the way you used somebody else's creative work? And we have a lot of case law on fair dealing. We know that you really can't define what it is or it isn't. It's not a question of you can quote somebody up to a paragraph and give and acknowledge who the author was, or you can quote a page. In certain circumstances, you can quote a page. In other circumstances, you can't quote a paragraph. It depends on what your purpose, what your intent is, and whether your intent infringes the creator's rights under copyright law. Now, in this concept of are you using somebody else's creative work fairly, we have changes in this legislation that are, for the most part, quite good. We're now saying you can use somebody else's work if the purpose is for parody or satire. Those words aren't creating any problems for us today at report stage. But they threw in education parody or satire. And the use of the word education does create some concerns. This is primarily because education as a term, as an exception under copyright use under fair dealing, has not been defined in the courts previously. It could lead to significant litigation, to expand or narrow the meaning in ways that are, shall we say, prejudicial to the average person who wants to use the material. And given that those people who might want to change the law in ways that restrict consumer access and normal opportunities to use materials are those with the greatest and the deepest pockets to go to court to prove this, it seems that we might down the road want to improve the way the bill currently reads and to create an opportunity by regulation for the governor and council to provide a definition of education. It's currently not in the bill. But to leave that flexibility down the road, that's what my motion number 3 stands for, that the governor and council may make regulations defining education. This is a very specific amendment that comes from testimony before the committees from Professor Giuseppina D'Agnisto, who is a professor at the Osgood Hall School of Law and Intellectual Property, also teaches at York University. And the comment that Professor Agostino had made back in 2010 when this was C-32 to explain this amendment was this, quote, "This would allow for a more evidence-based approach and allow government departments with expertise to hopefully collect evidence and be specific on what they need to cure by legislation and to be nimble and flexible in making adjustments to copyright problems in the educational sector as they arise from time to time." So that's all I propose to say on fair dealing. It's a big topic, but I want to move on to the question of digital locks, and most of my amendments relate to this problem. Digital locks make sense. I mean, this whole scheme of legislation is about protecting the rights of a creator and balancing the rights of the creator with the rights of the consumer. But as the legislation says in its very first lines, the point that what this legislation is attempting to do is to bring Canadian law up to speed with international obligations that Canada has undertaken through what's generally called WIPO, the World Intellectual Property Organization Copyright Treaty. The problem we have with C-11 is that it extends well beyond WIPO requirements. In fact, it's created the most restrictive scheme anywhere, among the most restrictive schemes anywhere in the world. The plain common sense explanation of this is to imagine that you could put a lock on something to protect it if you have a right to do so, and no one has the right to break a lock if that's your property, and getting through that lock is the same as stealing. But we have exceptions here that say you can use people's intellectual property, you can use for creative purposes, for satire and for parody. What if you have no right to lock it away? Then, under this law, breaking the lock is still illegal. It was explained well, I thought, by John Lutz, speaking about previous C-32 of the Canadian Historical Association in testimony before the committee. And what he said was, quote, "The new law brings copyright legislation, last amended in 1997, into the digital age. Consumers will, for example, be able to make private copies of digital works to carry on different devices like an iPod, a smartphone, or a laptop, without breaking copyright. There is, however, one important exception, and that is if the vendor does not want you to make a copy. All a vendor has to do is make otherwise legal uses illegal, is to put a digital lock on it." A digital lock, it goes on to describe. Now, this legislation not only says you can't break a digital lock, it also says it's illegal to produce the kinds of equipment or technology that would help someone to break a digital lock. My amendments essentially, without going through each of them one at a time, speak to the following principle. If in all other circumstances under this Act, the use of that material under a digital lock would be legal, you should be allowed to break the digital lock. A digital lock should not trump all other rights under this law. When it is fair dealing, when it is otherwise appropriate, when someone wants to get access to that material from something as simple as the mistake I made once in Amsterdam of buying a movie I really wanted to watch, got back to Canada, and I still can't see it. I asked the Minister of Heritage to consider these circumstances in which no one has any intention of breaking copyright. They just want to be able to watch something, view something, access something that they normally have a legal right to do. Digital locks should not trump all other rights. I commend the Minister of Heritage for his hard work, and I ask him to please consider amendments at report stage to improve this legislation. Thank you, Mr. Speaker.